Hi, welcome back to Frequently Asked Fridays, where we here at Martin IP Law Group answer your questions regarding intellectual property, including patents, trademarks, copyrights, and trade secrets. Today, we're going to answer the question, how long can I wait before I file my copyright application? So if you've looked at some of our previous videos, you know that copyright protection attaches when a work is created and or published, and that registration with the Copyright Office isn't necessarily required for you to have rights in that work. However, there are a couple of really good reasons to register your work with the Copyright Office and to register that work sooner rather than later. First off, if you want to sue someone, you have to have that work registered with the Copyright Office before you can file suit. So if somebody is infringing, you have to go through the step of registering that work before you can sue them. Oftentimes, if they are infringing and you discover that before you have registered the work, we can register that work for you. We can ask that that application be expedited, but there's an additional $800 processing fee associated with that process to get it expedited. So it's a good idea to register that work sooner rather than later to save yourself that extra cost that's involved with expediting an application. Second reason, and probably the bigger reason in order that you should register it first, is a concept called statutory damages. And statutory damages are damages that are available to you as a copyright owner regardless of whether you can prove actual damages. And these are set and determined by the court at a value that's set by statute. Currently, I believe that is set somewhere between $750 and $30,000 per act of infringement. There are additional enhancements if that infringement is found to be willful infringement, up to $100,000 per act of infringement. That being said, the statutory damages are only available if your work was registered prior to that infringement taking place. So if you follow the scenario where you wait till the infringement occurs, you expedite the application, you get your registration, yes, you can stop them from further copying your work. Yes, you can get damages to the extent that you can prove you were actually harmed by that infringement, but you're not eligible for statutory damages, which is a big plus for copyright owners. So in order to make sure that you don't lose out on the maximum amount of protection for your copyright and that you don't miss out on statutory damages if someone infringes your work, register that work as soon as possible. Thanks for tuning in. We hope this information has been helpful to you. If you have other questions regarding intellectual property, please visit our website or give us a call at the number shown here on the screen. We'd be glad to talk to you and answer any questions that you may have about intellectual property. Have a great weekend.